Hello and welcome to our September webinar, a collaborative presentation of the Federation for Children with Special Needs and the Recruitment Training and Support Center. Today's webinar topic is Basic Rights in Special Education, presented by Elizabeth Topaz. Liz is the Senior Trainer for the Parent Training and Information Center of the Federation and a parent of a young adult with special needs. Today she will discuss basic rights and procedures in the special education system, including referral, eligibility for special education, and the basics of developing an IEP. During the webinar, please type your questions in the toolbox and we will try to answer them during the presentation. Also, past webinars are archived on our RTSC website, along with many resources on trauma and learning and educational issues that impact students and child welfare.
Welcome to Understanding Basic Rights in Special Education in Massachusetts. And I see my slides are not moving. So we're going to have to go ahead and I'm going to let the other people work on that and I'll start talking to you. So we're talking about basic rights in Massachusetts. I want to clarify that under the federal special education law, and we'll talk about that in a minute, whichever gives a parent and a child greater rights, whether it's the state law or the federal law controls, there are certain rights accorded to families in Massachusetts and students in Massachusetts that do not apply in other states. So although much of this material will apply to other states because it's based on federal law, some is specific to Massachusetts. I also want to make a note that basic rights, although it's the title of this presentation, does in fact not mean that this is simple rights. This is complex and detailed material. We do recommend that parents attend webinars or local workshops more than once in order to retain the material. So please don't be intimidated and don't be concerned if you're unfamiliar with the material. You can come and go over it again, and that's fine. So the goal of our workshop today is to understand your basic rights under special education law, understanding the procedures, and the ultimate goal is to provide you with information so that you can better participate in the special education process and collaborate with your school. So the special education laws, I referred to them earlier. The federal law is something you may have heard of. It's called the Individuals with Disabilities in Education Act, or IDEA, I-D-E-A. And on this page, we have the formal citation to where the law and the regulations is found. If you're unfamiliar with regulations, those are an agency's rules to implement the law, and those are also controlling, as is the law. In addition, in Massachusetts, we have a special education law. Many people refer to our special education law as Chapter 766, but it's actually found in Massachusetts General Laws, Chapter 71B, and the regulations are down there too. At the end of this presentation, we will have resources that give you websites that you can look up the laws. It's really important to understand the congressional purpose behind the special education laws. We in Massachusetts are very proud of the fact that we had the nation's first special education law and the law on which the IDEA was ultimately based on, even though there are some significant differences. So the purpose is to ensure that all children with disabilities have access to a free and appropriate public education designed to meet their unique needs and prepare them ultimately for further education, employment, and independent living. That's really important. What that means is that your child with a disability is simply entitled to an education that's appropriate for them, just like every other child in the school system. Here we have a picture of the important timelines in the special education process. We'll be reviewing these timelines as we go through, so we're not going to spend a lot of time on this slide, but please note that this slide shows that there are approximately 50 days from the time that you first initiate the special education process until an IEP is developed. You'll note that this diagram shows those 50 days as school days. Please keep that in mind when working with the school. A school day is not the same as a calendar day because it excludes weekends, school holidays, school vacations, and summer vacation. If you request the process to start in May, there probably won't be 50 school days left in the school year to develop your IEP, assuming the child requires one, and so it will go into the next year. So keep in mind the times and the differences between calendar and school days when looking at all this. We'll talk more about this process in just a moment. So here we're going to begin with the very first steps in the special education process. Some people watching this video may have already gone through this. It's still good to know, and I'll explain why in a moment. So the first steps are the referral, the consent form and signing it, evaluations, and the convening of a team meeting. So why would you make a referral? Perhaps there are concerns about the student's development. You can make a referral. Your child's teacher may make a referral. Perhaps there's a specialist working with a child or a concerned adult. All of those people can make a referral. A referral is very important because it begins the evaluation process, and the evaluations are what determines what special education services, as well as goals, are going to be implemented for your child. So a referral can be made at any time. I earlier said that even parents who have a child that's already in special education might have an interest in learning about this, and here's why. Because a referral can be made for a child that's on an IEP. Perhaps there's a new area of concern. Maybe when your child was in kindergarten there were social emotional issues, but they're in 2nd or 3rd grade now and still can't read. You could request an evaluation even though your child had already had an evaluation in another area earlier and is on an IEP for it. That's fine. Bring the request to school in writing. Submit it to the principal or the director of special education. Many parents choose to walk down to school and ask for a receipt so that they can keep track of when it was requested. After the referral is made within 5 school days, the school needs to provide a consent form to you. In order to conduct any special education evaluation, your school system needs your written consent. Until such time as you respond to that evaluation with some form of consent that's in writing, they cannot do an evaluation or implement any special education. So it's important to look at that evaluation consent form promptly and act on it. So here we have a picture of what it looks like. It looks like a big, intimidating official form, but it isn't. It's a simple one-page form. I don't want you to be concerned when you get this in the mail. It's not a notice that somebody's done something wrong. They're just asking for your permission. By the way, if they ask you to consent to several tests, you may note on here that you only want some of them, or you may consent to all of them. So we've already discussed that the school sends it within 5 days. The next step after you return that form is the school has 30 school days, again that's school days excluding weekends, vacations, holidays, to conduct an evaluation of the child. So if you put it back in the mail, that 30-day period starts when it arrives in the mail at the school. If you walk it into the school, the 30-day period starts that day. So which assessments might be performed on a child? A child must be assessed in the area of suspected disability. The child to which I was referring before that we already know has a social emotional issue, but we're concerned about the reading, that child needs a reading evaluation. But in addition, no matter what the area is that's being assessed, the school has to include certain things. A history of the child's progress, an assessment of the skills that they need to learn. For example, attention, behaviors, communications, social skills, all of those. A description of the student's educational and developmental potential. Consequently, nearly all evaluations include some sort of IQ testing. So there are other assessments that can be done. A home assessment, a health assessment, a psychological assessment. Also, if you're in a home that the language spoken isn't English, or the student's native language isn't English, the student has certain rights, and the parents do too. But the student's rights pertain to that child must be tested in both English and their native language in order that we can assess both how they do in the classroom and the actual skills that they've attained. Sometimes the child has mastered skills but not English. Sometimes English is the obstruction. Sometimes the child's learning disability is the obstruction. So it's important to test in both languages. So after the 30 school days have passed, or sometimes a few days before, it's usually not a lot before the end of the 30-day period, the evaluator prepares a written report. They discuss the procedures used, the results, the diagnostic impression, the student's needs, and recommendations to include specific means of meeting that child's needs. That doesn't mean that those are the needs that those are the methods that the team will adopt. However, an explanation of at least one way to meet that student's needs have to be included in there. So the team meeting must be scheduled to discuss the evaluation results. Team meetings need to be held at a mutually convenient time. That doesn't mean 10 o'clock at night. It's typically within the school day or at the end of the school day. Most schools require that team leaders try at least 3 different times to schedule a meeting. If you cannot attend a meeting, then you may attend by Skype or by conference call. That's included in the regulations. Also, if the times that the school is offering you are this Tuesday at 10, next Tuesday at 10, and the following Tuesday at 10, you're entitled to say, I'm sorry, Tuesday is the one day that I cannot make it. Can we do it one of the other days? The school needs to work with you on really scheduling a mutually convenient time. The material at the bottom of the page is very, very important. You will not see the report before the meeting unless you request it in writing. If you request the report in writing ahead of the meeting, the school is required to provide it to you 2 days before the meeting. We strongly recommend that you do so and that you spend time before your child's team meeting reading and trying to understand the reports. That way, you can come to your meeting prepared, you'll understand what the evaluator has seen and recommends, and you can bring a list of questions to ask them and be ready to discuss the recommendations included in the report. Otherwise, you'll attend the team meeting and it will be like a big surprise that's sprung on you. And sometimes it's a very big surprise and not in a positive way. It's always good to be knowledgeable when you walk into your team meeting. Okay, we're now going to move on to the eligibility determination. So after an evaluator has produced the written report, a team meeting is convened. As we discussed, it should be held at a mutually convenient time. This diagram represents who's on the team. The only person in this diagram that is not always on the team is the student. The student must be invited to the team meeting once they turn 14 in Massachusetts. The student may be invited to the team meeting earlier if appropriate. It's probably not appropriate to ask your 6-year-old to come to the team meeting, but a 12-year-old with a learning disability who might have some strong opinions on what works for them and what doesn't, perhaps should be included, at least for part of the team meeting. In addition to that child, the parent is a very important part of the team. The parent is part of the team and is equally important with all the other team members. There needs to be a school administrator, one who is familiar with the resources of the school. There needs to be a general education teacher as well as a special education teacher. Any related service providers like speech therapists or physical therapists if the child is receiving that service. And in addition, there needs to be somebody who can speak knowledgeably about the evaluations. It is typically, although not always, the evaluator. So sometimes it will be the related service providers, a speech therapist, an occupational therapist, a counselor. Sometimes it will be another person with the appropriate training and knowledge. Lastly, others with additional information. It might be a principal, it might be another teacher. I should stop here and note that parents may bring anybody they want to this team meeting. We recommend that as a courtesy, you notify the school in advance if you bring other people. But you may do so. You may bring a friend for support, a relative for support. You may bring a special education advocate or even a lawyer. If you bring a lawyer and you don't tell the school is going to postpone the meeting until they can bring their lawyer too. Again, it's good to tell the school. We encourage it both as a courtesy and so that you can maintain good communications and a strong relationship with your school. So we've talked about who's on the team. Now I'd like to talk about who doesn't have to attend the team meeting. The answer is that aside from the student who's invited and has the option to attend or not, although we recommend that they do attend if they're 14 and up, no team member can be excused unless the parent agrees in writing to do so. You have the right to ask that the meeting be postponed to a date that the entire team can be there. You need to think in advance about who's essential and who isn't to the team meeting. If you're there talking about a learning disability, maybe it's not so important to have the physical therapist there, and maybe it's more important to you to get the team meeting done and come to a consensus. On the other hand, we would certainly want the reading specialist or the special education teacher there for a team meeting. So that's something that you're going to have to think about in advance, because you have the right to wait on the team meeting and have them reschedule it to a time that everybody is there. So think about these situations in advance so that you'll be prepared, because sometimes people are sick, sometimes there are conflicting obligations. So when the team meets, first, of course, presumably everybody will introduce themselves and you'll be asked to sign a sign-in sheet. But when the team meets, and it's within 45 days of that first consent, so they have 30 days to do the evaluation and another up to 15 to hold the team meeting. So the team convenes, it reviews evaluation results, and it determines eligibility for special education. There are additional tasks once this is done, but these are the initial tasks. So once the team meeting gets underway, the reports may be summarized by the specialists that talk about it at the team meeting, but then they'll use this chart. This is a flow chart developed by the Massachusetts Department of Elementary and Secondary Education. And we'll go through this chart in detail on the next 2 pages, but this is the chart that they will use. And when I say they, I'm talking about the team. That includes you and the members from the school to determine eligibility. So the first step in determining eligibility is to determine whether the child has a disability under the law. I say under the law because the disabilities defined by the law that are subject to special treatment, to special education, are not just any disability. Many of our disability laws address all disabilities. This law has specific disabilities: autism, developmental delay, Intellectual disability. Sensory, that would be a hearing or a vision or a blind deaf. Neurological, emotional, a communication disorder, a physical disability, specific learning disability, or a health impairment. So just a couple of notes on that. The first one is with regards to health impairment, that includes diagnoses such as ADHD or Tourette's syndrome. A lot of people don't know quite where that goes. It's a health impairment. Further, developmental delay is applicable only to children 9 years and younger. Once they hit the double digits, they should have a different diagnosis, or a different, not a diagnosis because the team doesn't diagnose, but a disability. So many of those kids will fall into intellectual disability, but not all of them. If a child can't be categorized into one of these categories, then they are not eligible for special education. They might be eligible for other programs that protect disabled people, and we will talk about that briefly later. So the second step, once it's been determined that the student has a disability under the IDEA, we ask a couple of more questions. Is this student making effective progress? There are students with disabilities who make effective progress in school without special education. If this student is one of those children, and we'll talk about what effective progress is a little later in this presentation, then that child is not eligible for special education. They might be, again, able to access other programs to help disabled students, but they don't need special education. Assuming that the child is not making effective progress, the team then determines whether the lack of effective progress is due to the child's disability. In most cases, that will be yes, but the team still has to evaluate whether that is the case. And finally, does this student require specially designed instruction in order to make effective progress? And in Massachusetts, we ask a second half of that question, or does that child require related services in order to access the general curriculum? Now, there are a whole bunch of terms that we don't use in our normal speech that you've just heard. Things like effective progress and accessing the general curriculum. We're going to talk more about those in a little while, but for the moment, that's the question we're asking. If you get all the way to that question and the answer is yes, that child in Massachusetts is eligible for special education. So, effective progress. It's the documented growth in the acquisition of knowledge and skills in the general education program with or without accommodations, according to the age and the developmental expectation of that child. Notice that the definition on your screen includes social emotional development. So effective progress is not determined solely by passing grades or being promoted from grade to grade. That's part of the discussion, but it's not the sole focus of the discussion. So, specialized instruction is a unique term. Specialized instruction is special education. It means that the special education teacher modifies the content, what's being taught, the methodology, how it's being taught, or the performance criteria. That just means the grading, the evaluation for the child as appropriate to address that child's unique needs and ensure that they can access the general curriculum. The other piece of that last bit of the analysis is, does this child require related supports or services? In Massachusetts, a child that just needs related supports or services can be entitled to special education. Many kids who need special education need both specialized instruction and related services. And on the screen here, you see some examples of related services. The most common ones are speech and language, occupational and physical therapy, and counseling. If the team decides that the student is not eligible for special education, then on that form that we spoke about a few minutes ago, on the right-hand side of that flow chart, we still have to answer the question, are parents satisfied with the school evaluations? And one possibility is to discuss extended evaluation rights and independent educational evaluations. We're going to talk about independent educational evaluations, or IEEs, later. Extended evaluations just mean that there's a longer period in which the school will observe and evaluate the student. So even if the student is not eligible for special education, they may be eligible for other programs. Parents have the right to appeal all the way up to the Bureau of Special Education Appeals if they disagree with this determination. We'll talk more about this later, but what we really want to emphasize is, and encourage, is that you develop a strong relationship with the school and try to work with the school so that it doesn't come to litigation. Because presumably everybody at the table at that team meeting has the student's interest in mind. So if the student is not eligible for special education, they might be available for something called a 504 plan. 504 refers to Section 504 of the Rehabilitation Act. And what that says is that students can't be discriminated against because of a disability. So there are a lot of differences between 504 plans and special education plans, or IEPs. Both of them allow for accommodations in the school, and we'll talk more in a moment about accommodations. Both require, you'll see there's more acronyms up here, FAPE in the LRE. We'll talk about both of these, but that means an appropriate education, hopefully in the general education classroom. They both talk about need and accommodations on testing. There are the same remedies for disputes or violations for both of them, but what's not required for a 504 is a written plan, progress reports, because we're not teaching them skills, we're just accommodating their needs. Annual team meetings are not required, although periodic reviews are. Discipline protections may be limited, and there's no transition planning under 504. So here's a good place to stop and take any more questions that may have come up. The team meeting needs to be scheduled for a mutually convenient time. If a school asks you to come to school tomorrow and you can make it, that's great. If not, ask for it for a different time. Now, there's one exception. If your child is involved in a discipline issue where there's a suspension, there is potentially urgency here, and there's not a tremendous amount of latitude. You can't really have a suspension hearing moved out a week or 2 weeks. So that's sort of urgent, but in the typical situation where you're developing an IEP, it needs to be mutually convenient, and if tomorrow isn't convenient, you need to be able to tell the school that. Well, that's a good question and a very common question. I first want to note that we can't really talk about very specific situations, but in general, many kids that have ADHD have 504 plans. It's really an individual determination when a kid, at least when a kid has ADHD, whether that child needs accommodations or whether the child, it interferes so much with their learning that even with those accommodations, they can't learn. Typically, if a student has dysgraphia, they'll need occupational therapy. And if you're in Massachusetts, occupational therapy should go on an IEP. So the team can reevaluate this. You can do it in a couple of ways. We're going to be talking about independent educational evaluations in a few minutes. And that would, once that's done, it would entail reconvening the team to discuss the new evaluation. You can also, you obviously can't have another evaluation a month later, but you can reconvene the team when things change. You can reconvene the team after, even if the situation isn't dramatically changed. You can ask for new evaluation a few years down the road. Maybe from the school's perspective, when the testing is done, you will see a change. You can always do your own testing and consult your own experts to ask them whether your child really needs some services rather than just an accommodation. We haven't discussed what an accommodation is, but we'll do so in a minute. Danny, are there more questions? If that question, I think, was asking, should my child be in a class where he's testing or she is testing at a higher level than the class is held? Goals should be challenging and attainable, and a student is entitled to access the general curriculum. So the team really needs to look at whether it's a challenging and attainable goal. Now, what we don't have in Massachusetts is any sort of formal statewide program for kids who really are academically at a higher level than anyone else. So we're entitled to push our kids up at least to the general curriculum level. Let's talk about 504 plans and college a little later, because we do have 2 slides towards the end of this presentation that touch upon transition issues. So we'll continue in talking about designing a special education program. So the special education program is contained in an IEP form. Once the team decides that this student is eligible for special education, the team will develop an IEP, including a determination of placement. They'll hold annual reviews of the IEP and reevaluate the student for eligibility every 3 years. This is what the first page of the Massachusetts IEP form looks like. When you get it in the mail, you may find that there's another form on top of this. That would be an N1 form. The N1 form simply lists the student's name, age, grade level, and the school contact information. This is the first page of the formal IEP. It's also sometimes referred to as an education plan. So sometimes some of these pages that we're showing as one page will be many pages, and this is one of them. We're not going to go through the actual IEP form in detail. I might add that the Federation does offer another workshop on IEPs, and that does go through that form in detail. You can go to our website at the end of this presentation and check when we are presenting. All of the presentations that we put up on our workshops page are free to parents. You can go, it doesn't have to be in your town, you can go in another town, that's fine. But we will discuss briefly the content of the IEP. So the first page, you'll see there's parent concerns, there's key evaluation results summary, and there's vision. And we'll talk more just in a moment about that. So the purpose of an IEP is to enable a student to access the general curriculum. Do you know what's in the general curriculum? The general curriculum is composed of 3 things. Massachusetts has something called curriculum frameworks. You can Google Massachusetts curriculum frameworks, and those will come up. If you do so, you'll Google it, you'll see math, history, English language arts, even health. Health is what includes social emotional. Some of these strands are quite old, some of them are much newer. In addition, local school districts have a district curriculum. And lastly, MCAS and MCAS Alt are considered part of the curriculum. What goes in an IEP? We're not going to go through the form, but this is what goes into the form. So there are parent and or student concerns. You should come to the team meeting with a list of your concerns that you want addressed. You can ask that they be included in the IEP, but even more importantly, you can ask the team to discuss these concerns during the team meeting. you need your concerns addressed. I also recommend that you at least think about, if not prepare in advance, your vision for the student. School districts approach vision in different ways. Some school districts, many school districts actually, try to work with parents to develop a mutually agreed vision. And once they're 14, your child should be developing a vision too. Some of them will have separate visions if the team can't agree, but we do encourage teams to try to work on that vision together, because you're working with the school. You ought to be working towards the same goals. So student strengths and key results. This will include results of testing and MCAS, as well as observations from the school, present levels of performance, and accommodations that are needed by the student. So those are some of the challenges that the student has, and accommodations to help the student access the curriculum. Modifications in specially designed instruction explain how the special education will be delivered, and related services as well. So once that section is done, there are goals and benchmarks that determine exactly what the student will be working on in special education that year. The service delivery grid, which says what services they're getting, schedule modifications, transportation, MCAS accommodations, and placement. You can see why we need a separate workshop just on that. There's a lot that goes into that IEP. So I'm sure at this point you've heard me mention accommodation multiple times. And accommodation is an important concept. An accommodation is what drives a 504 plan. That is a plan for accommodations, but accommodations are also included in IEPs. So a change in the learning environment, for example, perhaps a student needs a smaller place to test. It allows access to the same information. Things like preferred seating, and if you have a preferred seating accommodation, we recommend that you ask for it to be more detailed than simply preferred seating. Some people assume that preferred seating is at the front of the room, but there are some kids that need preferred seating in the back of the room so they can pace, or seating away from a window, or away from certain students, or near certain students. So be specific on the preferred seating. Don't be afraid to ask the team to clarify that for you. There are students that may need digital books and taped lectures, and I'm not only referring to visually impaired students that may benefit from that. If you have an older child with a reading disability, it may be that they need digital books and taped lectures for some of their classes that aren't English, for example. Or perhaps you have a student with executive function difficulties, that's challenges in planning and organizing, that can't take notes well enough and need a taped lecture. Sensory breaks, reduced seat time. The child who's always fidgeting and bouncing up and down, they might do much better with 5 minutes in the back of the classroom just moving around. Reading and writing software, graphic organizers. All parents become familiar with those at some point during late elementary school, I think. Some students will need them in a broader array of areas and as they progress through the school system. Computers and large print materials. All of those are examples of accommodations that may be appropriate for your student on an IEP. So we talked about free and appropriate education. That is what your disabled student is entitled to. So the standard, free, of course, means no cost. Appropriate, the student is entitled to make meaningful or effective progress towards challenging IEP goals. The standard in Massachusetts is what challenging yet attainable within 1 year goal should we create. It's a public school system. You're not entitled to a private school except under very specific circumstances. And it goes all the way from elementary school in preschool actually for some kids, all the way until the child graduates or turns 22, whichever is earlier. So the least restrictive environment. We emphasize that students are entitled to be educated in the least restrictive environment. So that's the standard for determining the placement of the student. Once the goals are determined, we look to see where those goals can be delivered. So to the maximum extent possible, the child should be educated along with typically developing peers in a general education classroom. If the child cannot be educated in that setting, only then do we consider other environments, and the least restrictive one is the appropriate one. So some students that can't be educated solely in a general education classroom will be pulled out for some things. For example, they may be pulled out for English language arts, or they may be pulled out for speech and language, but they'll be pushed in for the rest of the time. So that's a partial inclusion program, or perhaps even a full inclusion. It's considered full inclusion if the student is there 80% of the time. As you can see, there are a number of other options, such as a separate classroom within the local school, or a separate private day school or collaborative residential school, and there are other places available too. But again, hopefully your child will be able to be educated in your local school along with all the other kids in a general education classroom. At the conclusion of the team meeting, you should walk out with a completed service delivery grid. The service delivery grid lists what services your child will receive. Will they receive speech and language? Will they receive special education? How many times a week and where? That should be filled in. There should also be a statement of the major goals associated with it, so that you'll know that they're working on ELA and math. You should expect the IEP within 2 weeks. Please note, you're not required to sign the IEP at the team meeting. We recommend that you don't sign it at the team meeting because you need time to process it and to read through it. It can be a complicated legal document. So once you get that IEP within 2 weeks after your team meeting, you have options. When you look at the IEP and you look at the proposed accommodations and services, you can decide that they're just what your child needs and accept the IEP. You can look at them and either say, this is not what I was expecting, or I disagree with the rest of the team. You can reject the IEP completely, or you can combine them, accepting in part and rejecting in part. We encourage parents that are not happy and feel that they have to reject the IEP to look at the IEP and see what you can accept. There's several reasons. First of all, if this is a new IEP, that means your child won't be getting any special education services if you reject the IEP in full. If you can accept, say, the math goal but not the reading goal, they'll at least get special education for the math services while you're resolving the reading goal with the school. Second, even if you have an IEP, and I'm going to talk about something called stay put in just a moment, when you rely on the old IEP under the stay put rules, there are old goals there. They're goals that your student may have met or come very close to. They may not be appropriate anymore. If you can accept part of those goals, some of those goals, but not others, at least you've got some new goals. So let's talk about stay put while we're here. There is a right called the stay put right, and what that says in Massachusetts, and it's different in other states, so don't assume that this is the rule if you're in another state. But in Massachusetts, if you reject an IEP and you have a previous IEP and you invoke stay put, you ask that the old IEP remain in place under the stay put rules, the old IEP will remain in effect until either a new one is agreed upon, or you agree that your child should no longer be on an IEP, or the third option is that the matter is resolved through litigation. So many students take advantage of the stay put rules and retain their old services while they are negotiating with the school to get an improved IEP. Parents need to send the response within 30 days. After 30 days, the IEP is deemed rejected. So it's a big, complicated document. A lot of parents take that document and put it aside until they have time and don't get back to it. Many schools are just fine if you take 60 days and then you sign it, but understand that it's assumed to be rejected after 30 days, and also that none of the services on that IEP will begin until you have accepted and returned it to the school. So please look at it, carve out the time to spend some time with it, and get it back to the school. Parents can request a team meeting to discuss the rejected portions. There's a box at the bottom of the response page that you would check off. I also encourage you to develop a good relationship with your team leader so that if the IEP is not what you expected, you can pick up the phone or send an email, perhaps ask for an informal meeting just with that school representative, and talk about your concerns and how they may be addressed. So we've already spoken about stay put rights, and we'll continue on to the response to the placement. So the options for placement: there is no accept in part and reject in part in placement. You either accept a placement or you don't. Again, stay put rights do apply. I might add, stay put rights do not apply to a building. So if your child is in 5th grade in an autism program at the local elementary school and you invoke stay put rights because you don't want them to move on to the 6th grade middle school autism program, that won't work. They're still in that would be a continuation of the same program. It's not a building, it's a program. So if the program is the same, even if the building is different, stay put would endorse that the building can be moved. So many parents get the IEP and, not being educational experts, don't know how to respond. I might add, while you may not be an educational expert, you do have an expertise that you bring to the team that nobody else does, which is that you see what your child looks like out of school, on the weekends, on those long vacations, at night after they've been at school all day. So there are some tools that you can use in order to help with your decision and your evaluation of the IEP. First, parents in Massachusetts have a right to observe any proposed placement. If you're working with a specialist, such as a neuropsychologist or an educational consultant, you are entitled to have them observe as well. You may go down and review the school records and request a copy of them. The school is entitled to charge you a copying fee if you request a copy, but it's got to be a reasonable fee. You can review the school records if that's going to help you. By all means, do so. Lastly, you can consult an independent expert. Perhaps you're working with someone, perhaps your child is followed by a developmental pediatrician or a psychiatrist or a reading specialist. Perhaps you want to go work with one. We'll talk about some of those options later, but you can always go at your own expense. It may or may not be covered by health insurance. You can ask your health insurance. Sometimes the providers will help you with that too. So once the IEP is accepted, the school needs to implement it immediately. The IEP has to be accessible to everybody who needs to implement it so that they can see what their roles are. You should expect that you receive progress reports as often as you receive report cards. That doesn't mean that you will get a progress report at the same time as a report card. But what it does mean is that if you receive report cards 4 times a year, then you should also be receiving these progress reports 4 times a year. The progress reports will let you know how your child is doing with respect to the goals in the IEP. You should expect a team meeting annually to review goals and progress towards the goals and to address new goals. Or if there is no progress towards the goals, to address why there is no progress. And parents may ask for a team meeting earlier in the year as well. Every 3 years, you should expect a reevaluation of the student with similar testing to what occurred before the first IEP. So, the IEP can be changed after a team meeting. If you agree to an IEP and you feel that the child has met a goal or needs a change of some sort, or the school feels that way, you and the school can agree without convening a formal team meeting. You may feel you need a team meeting to hear the input of the entire team, or because you don't necessarily agree with the school's recommendations, but if you agree, you can change it. To do so, you would need to have a formal amendment that you signed. Parents are required to consent to all IEP changes. Schools can't simply go ahead and unilaterally, that means by themselves, change an IEP without your consent. So here's where we get into a brief discussion of transition planning. And so starting at age 14 or before, the transition planning form should be used. Really, it should be filled out before the IEP has been drafted. So after the student is determined to be eligible for special education, the transition planning form in Massachusetts should be prepared. This is a form that's unique to Massachusetts. I'm sure that many states have similar forms, but when we're talking about TPF, we're talking about Massachusetts. Similarly, the transition planning age is not 14 in every state. The national standard is 16. Some states have other rules. So really, this should be done for the IEP in which the student turns 14. The reason that it's important is that you begin to focus on the student's post-secondary vision. That includes further education, maybe vocational, maybe college, employment. This might include supported employment, adult services, independent living, travel training, and so much more. Don't be concerned when your 14-year-old tells the team that they're going to be a pro football player or an actress. That's actually developmentally normal. It's normal for children and completely appropriate for every student, whether they have a disability or not, to change their vision as they mature. At 14, it may be a football player. At 16, it may be a broadcaster. And by 18, maybe that student is just interested in journalism, which is sort of a more typical career path. So that's fine. As far as going on to college, by the way, it's useful to have a 504 or an IEP to show to the College Disability Services Office. There are rules. The 504s do apply to college. You may not get the exact same accommodations, but you should talk to the college and see what requirements they have. Some colleges require that you present testing and recent testing, but colleges typically do have, often adopt the same accommodations as at school, and all colleges are required to accommodate students with disabilities. So all of these things, I might add, are as appropriate. There are some students that are in special education who will be going off to a four-year college with minimal accommodations after high school. There are other students who will stay in school until 22 and then go on to have a number of adult services supporting them. All of those are covered by transition planning. The transition planning form is then, by the way, used to develop the IEP form. So inevitably, sometimes there will be disagreements between the school and the family regarding a student's education. I might add this happens in non-disabled situations too. The best approach is really to develop a good relationship before the disagreements happen so that you can work collaboratively with the school to resolve the disagreements quickly and amicably. The outcomes are more mutually satisfying, and most importantly, the solution gets implemented and implemented more quickly. It benefits the student. Students do not benefit from an atmosphere in which families and schools feel like they're at odds with each other. Local options are the best options and certainly are your first route for resolving disputes. Team meetings. Don't be afraid to talk at team meetings. It's really hard for parents, especially when they are in the early years of the special education process, to feel comfortable speaking at a team meeting. You're entitled to ask as many questions as you need to. You're entitled to participate in the team meeting. The team meeting will be more productive with your participation. Bring your concerns to the team meeting and address them there. If you need to, you can obtain an independent educational evaluation. We're going to talk about that in a moment, but that's an outside tester who can test your student for you on some of the issues that the team is addressing. And finally, if those don't work, or maybe even before some of those, you can meet with your principal, your special education director, or the building person in charge of special education, or the superintendent. Okay. So let's talk about independent educational evaluations. Independent educational evaluations are when an expert comes and tests your child, or your child usually goes to them. They are not employed by the school. So, if a parent disagrees with the conclusions of one of the evaluations that had been discussed at the team meeting, within 16 months of that evaluation, they can let the school know that they disagree and they want an IEE. This is income-based. I believe it's up to 4 times the poverty level. And there's a sliding scale as well. If the parent doesn't disagree, but rather an area is simply not addressed, the speech and language doesn't address the child's stuttering, the parent can simply request that IEE be done. And the third is that an IEE can be done at your expense at any time. A couple of things about IEEs. First of all, when the school is paying for the IEE, the tester must accept the state rate. It can be hard to find a tester that will accept the state rate. Many private practices do not. Most of the major hospitals do. Please be aware that there is often a waiting list for those appointments, so you should try to plan in advance as much as possible. Also, after you request the IEE, the school must respond very quickly within 5 days. So don't be surprised if you automatically get a letter that says something like, "We are denying your request for the IEE, but if you give us your income information, then we might reconsider." They're doing that so that they don't miss their 5-day deadline, but they're also telling you that if you provide the appropriate documentation on your income, that they might consider it. So don't be intimidated by that notice. They have to do that. Okay. Once an IEE is performed, whether you've paid for it, your health insurance has paid for it, or the school has paid for it, the team must reconvene within 10 days of receiving the report. Many parents make the mistake of getting their child examined and not submitting the report to the school and coming to a team meeting with the report. Most likely, that team will not consider that report at the team meeting. You'll have to wait 10 days. Parents are not required to submit reports to the school, but if you want the school to consider it, please keep in mind that it has 10 days to read and review the report. Just as we've recommended that you review the reports before you go to your child's team meeting, they also want to do so. If the local options don't work, there are other options. First of all, you can call PRS. PRS used to be known as PQA. A lot of parents refer to PRS as PQA. It's now known as the Problem Resolution System. And the phone number is up on the slide. They will address issues of not complying with the IEP or not following state laws. They are a part of the Department of Elementary and Secondary Education, so they're a Massachusetts entity. They will look into your complaint and address it. We encourage you not to call for the most minor violations. If a report is to you a day or two late, they're really not going to do anything about it. However, if reports are coming to you consistently months late, that might be a more appropriate thing if you can't remedy it yourself. OCR is the Office of Civil Rights. They are a division of the U.S. Department of Education. They will address civil rights violations if your child is not permitted to participate in certain activities at school, for example, because of his or her disability. We also have some great alternative dispute resolution systems in Massachusetts. These items shown in yellow in the boxes are administered by our mediators. They work for the Bureau of Special Education Appeals, but they're mediators, they're not hearing officers. They are available on a limited basis to facilitate team meetings. What that means is they can attend a team meeting if things are getting very hostile, there's a lot of animosity, and inappropriate actions are being taken, statements are being made that you don't feel are appropriate. If both the parent and the school agree to it, it can be facilitated by the BSEA, and sometimes that's very useful when tensions are very high. Also, mediation is a great system of resolving disputes. In mediation, the mediator will work with the school and the family to find a solution that's mutually agreed upon. No one has to accept the results of either a facilitated team meeting or a mediation unless they agree to it. Hopefully they will. On a worst case basis, you can bring the matter to the BSEA for a hearing. There'll be a resolution meeting and formal litigation. We recommend that families are represented by attorneys at the hearing. However, with the other methods, such as mediation, there is no need to, and many people go without attorneys, and it works just fine. So we have a graphic representation here of the full IEP cycle. The top part of the screen is the 3-year process, and it's where you would start with a referral and reevaluation, or reevaluation at the top left. So there's the referral, the consent, and the evaluations, as we discussed at the beginning of this presentation. The team determines eligibility and then meets to develop the IEP. Now, every year, there'll be a discussion about goals and placement. The IEP goes to the parent. There's the response and the implementation of the IEP. So, the Parent's Guide to Special Education is online, and there are 6 key principles of the federal law, the Individuals with Disabilities in Education Act, that we want to remind you of. Parent and student participation in the team, appropriate evaluations, an individualized education program that provides for free and appropriate public education, FAPE, in the least restrictive environment, LRE, and IDEA provides for procedural safeguards, the due process such as we just talked about with the BSEA. Here's the link to the Parent Guide. So, strategies for success. Know your basic rights. Come watch this again. Come to one of our workshops. Read the Parent's Guide so that you know what to expect. Use good communication skills with the school. We also, by the way, offer a workshop on effective communication. Be prepared to actively engage in a cordial manner with the team. Keeping in mind, your child's unique needs and keeping your eye focused on whether they're making effective progress. Set high expectations for your child and encourage the rest of the team to do so. And don't let the goals stagnate from year to year. Consider whether you need to go out for independent evaluations. Seek assistance from the Federation. We have a number of resources. In addition to our workshops, we have a call center whose number you'll see in a moment. When you call us, we're likely to have to call you back, but we'll call you, and our job is to provide free information for you. You may call as often as you wish, and we're happy to assist you. If you need support, do not forget to bring someone to a team meeting, especially if your emotions run high. Work with your local PAC and learn all you can from others. Acknowledge your gratitude to your teachers and thank them for working with your child. Keep in mind the 3 Ps: be positive, professional, and persistent. Thank you for coming here today to our webinar and joining us. I hope you join us in the future for our workshops and call center. Thank you. If in fact you did so and you pointed out to the school that they were inappropriately removing services, you could call the problem resolution system and ask if that was appropriate. Of course, we can't give legal advice here, but that's something that they might handle if it's not appropriate. That's a really good question. There is a letter from the Department of Elementary and Secondary Education that indicates that it is their position that parents and experts are entitled to as much time as they require. In particular, experts sometimes do need a full day or a half day to observe. And if you need a reference to the letter to which I'm referring, please call our call center and we can send you a copy of that or refer you to the link.
Okay. Someone asked what a resolution meeting is?
A resolution meeting is a meeting called by the hearing officer at the Bureau of Special Education Appeals when a parent has a significant dispute about the contents of an IEP and choose to litigate that at the Bureau of Special Education Appeals. It will be assigned to a hearing officer, and before it can go to hearing, there is always a resolution meeting. There have been parents who have been successful on their own in front of the BSEA. However, usually they're not, and the reason is that it involves a lot of technical legal issues, and attorneys have a lot of experience developing evidence and arguing evidence and how it supports their case. It's a pretty technical thing. Hearing officers will extend every opportunity to parents that they're able to, but they're not able to make the parent's case for them. An attorney will know what kind of things will demonstrate that the IEP doesn't provide a free and appropriate education, and will understand the technical issues better. So I would say it's really a case-by-case basis. I think the parents that have prevailed at the BSEA have found some public organization that's able to give them some legal advice sort of behind the scenes. So you can go to the BSEA, but you are likely to lose at the BSEA, and it's probably advisable. It's certainly advisable that you work with the school to try to come to an agreement.
Does an advocate for the family have the right to go to mediation with the family?
An advocate absolutely has the right to attend mediation. Parents can bring whomever they want. They can also bring an attorney. Of course, if you bring an attorney, particularly if you bring an attorney, you should be letting the school know that too, because they will want to bring their attorney as well.
Okay, so just a couple of announcements. Also, too, if you did ask a question or had to jump off early, any questions can be answered offline, so please feel free to contact the Recruitment Training and Support Center or the PTI Call Center, and you definitely will get your questions answered. Just wanted to follow with a couple of announcements. We have the FCSN 5th Annual Walk on October 1st. Gather friends, families, and coworkers for a fun and family-friendly event. Just please go to fcsn.org for more information. And also we have our Recruitment Training and Support Center 6th Annual Making a Difference Conference. The topic will be a community approach to trauma sensitivity. And that also registration is open, and you can go to the fcsn.org/RTSC to access the registration and more information.